Good afternoon, everyone. Welcome to today's webinar. FMCSA Clearinghouse goes live January 6, 2020. We will be going over the potential landmines today and how to avoid those. Of course, we want to go over our legal disclaimer. This presentation is for educational purposes only, and it is not intended as a substitute for the legal advice of an attorney. We are just ecstatic to present Tommy Eden today. He is our presenter. He's with Constangy, Brooks, Smith & Profit, and they are a management labor law firm that is nationally. Tommy's law practice is principally in the areas of management labor and employment law, along with drug testing law covering both DOT and non-DOT throughout the United States. We are very excited to have him with us today. Mark Jessup is our VP of IT, and he is kind of the man that's going to be combining the FMCSA with a program that we offer, Wolf One, which I'll go into in just a minute. But I do want to introduce myself. I am Melissa Michalunas with Wolf. Just some housekeeping rules here. You can ask questions throughout the presentation by using the Q&A or the question and answer section there on your screen. We expect to have lots of questions, and if we do not get to all of those, we will reply to all of those typically within around 48 hours, and Tommy will be giving his attention to each one of those questions that is answered that we send a response out to. So this is Wolf One, and I won't take long on this, but we are really excited at Wolf to announce our newest software. It provides management and storage of driver qualification files, record management for drug testing and background screening in one location, which is great. And it can also provide expiration notifications for things like physicals or MVRs. And those are things that are customized to your specifications. We will be hoping to include FMCSA in this. And so we're still in the informational stages of that, but we can promise that we will have cutting-edge solutions for the FMCSA, and that being included in Wolf One. We will be doing an online demo of Wolf One to share with you the benefits and user-friendly access in the upcoming months. So keep an eye out for that for the notification of dates. And if you would like a demo before that, please feel free to reach out to any one of us here at Wolf. So Tommy, do we have you on?
Yes. How you doing, Melissa? Thank you so much for allowing me to. Wolf, as you know, Wolf has been a long-term client of Constangy, Brooks & Smith, and it has been my pleasure to work with the wonderful folks at Wolf. So thank you very much for today.
Absolutely. We're excited about this. So let's just dig right in, Tommy. So one of the things is, Tommy, would you just help us or give us 5 learning objectives for the training today, and then also who these clearinghouse regulations, who specifically will they affect?
Thank you, Melissa. So I want to say a welcome for my firm, Constangy, Brooks, Smith & Profit. We have 30 offices across the country, approximately 180 attorneys, and we are exclusively management labor lawyers. I am considered the drug testing guru within the firm, or they call czar. So whatever title you want to use is great. So welcome on behalf of our firm as well. So what I want to do is do a section-by-section clearinghouse walkthrough. I want to talk about the issue of refusal to test. There are 2 big issues, and I'm thinking I'm talking mostly to employers here or maybe some TPAs out there. The refusal to test issues under the clearinghouse and the actual knowledge issues under the clearinghouse are issues that you need to pay great attention to, because how you make a report to the clearinghouse in the future is going to be extremely important that those be accurate, that they be based on evidence and not on hearsay, and we'll talk more about that. So we'll talk about those topics. And then 4, what are the compliance landmines? So I've identified 9 different landmines within the clearinghouse regulations. I was privileged 2 weeks ago to present on a panel with the FMCSA up in Detroit. So I was able to look at their screenshots. They never shared their slides with you, so I was able to watch their slides and then take photographs of someone with my phone, and then go back and study things. So I think I found some really nuggets to help you today. So what DOT regulations require that your fleets update their FMCSA policy? So I will tell you that is probably the biggest issue of compliance right now. Is we're helping our clients across the country update policies and forms toolkits to help you be ready, because every policy that does not include a thorough discussion of the Clearinghouse regulations will be out of compliance as of January 6, 2020. So getting them updated now is very wise counsel. So who does it affect? Everybody in this industry. So it affects employers, service agents. These are people like your MRO, your drug testing collector, the laboratories, the substance abuse professionals, or all those are service agents. And it uniquely affects cloud service providers because they will house Clearinghouse data. They may not know it, but they will be also covered. It affects employees. Every regulated driver, every CDL driver in the country will be affected by these regulations. Historically, this act was actually signed on July 6, 2012. And it's called the Moving Ahead for Progress in the 21st Century Act. The FMCSA is highly motivated to make sure that this goes off without a hitch on January 6, 2020. So one of the issues that Melissa and I talked about is why the country needs this clearinghouse. There was an incident that happened in June of 2019 involving a driver out of West Fairfield, Massachusetts, age 23, charged with 7 counts of vehicular homicide after colliding with a group of motorcyclists in Lancaster, New Hampshire. These motorcycles, if you remember this, it hit the huge splash in the paper about this and tragedy. These were Marines. I don't know if some of them were retired Marines, but they had formed a motorcycle group that they'd go out riding together. And there's a large, probably at least 10 of them in the group, and 7 of them died in this tragic accident. The driver had a commercial motor, a CDL. He had a troubled arrest record with drug charges and traffic incidents spanning at least 6 states. If you just Google his name, you will be, so that's a picture of him. So you will be astounded exactly his past driving record as well. So how could a man with such a checkered past possibly have a commercial driver's license? Well, what happened, the Massachusetts Registry of Motor Vehicles has admitted his license should have been revoked following a drunken driving incident or arrest on May 11th in Connecticut. Remember, this accident happened in June of this year. And then the Connecticut failed to provide sufficient information about the arrest through the proper channels outlined in what's called the Federal Commercial Driver's License System. This is what state regulators who issue commercial driver's license use. Records from the FMCSA indicate that the company he worked for, Westfield Transport, had been cited for various violations of the DOT regulations in the last 2 years. The head of the Massachusetts Registry of Motor Vehicles resigned amidst all the fallout, and the Massachusetts Motor Vehicle Administration did not act on information provided by the Connecticut Department of Motor Vehicles on the May 11th incident. I really think that this incident would not have happened if the clearinghouse would have been in existence and utilized in June of, because the arrest in Connecticut happened 3 days. He had worked for Westfield Transport for 3 days. I mean, before the accident in June. So it's tragic, but why do we need the clearinghouse? We need the clearinghouse to avoid exactly this kind of tragedy.
So, Tony, please break down the Clearinghouse regulations for us, and when this all goes live, I think that would be very helpful.
So one of the things I'm going to encourage you to do a few things as we go through. One of those is to download all the regulations. Now, you'll have a hot link on the presentation materials, and I highly recommend that you download them. And what I want to do is I want to talk to you about them in section by section, because that's the way you're going to review them, and that's the way you need to kind of reference back on them. So if you look at the sections, there are 382, there's 49 CFR Part 382, and then there are subsections of 700 series. So everything is in the 700 series. So the first part in the 701 is the employer's background check responsibilities. That's in the 701 part. We're going to detail these more. In the 703, the driving consent requirements. Very, very important that there be a valid driver consent for these background checks. In the 705 series is the reporting of the clearinghouse. You'll see there are 6 different entities with reporting responsibilities, and each one of them has different timing and they have different procedures. So you've got MROs, you've got the employer, you've got the employee responsibility, which you'll find kind of unique when we talk about how that works. The TPA, third-party administrator, this is like Wolf, is the third-party administrator. The substance abuse professionals, and then the reports have all got to be truthful and accurate. In the 707 series, the notice to the driver and the other issues about placement, revision, removal, or release of information. In the 709 is the driver's access to information in the clearinghouse. In 711 is clearinghouse registration, which will open in October. So we are 1 month away from opening clearinghouse registration. 713 is the duration, the cancellation, and the revocation. In 715 is the authorization to enter information into the clearinghouse. 717 is procedures for correcting information in the database. We're going to talk about that, and you'll understand why those are potential landmines. Availability and removal of information in 719. The fees that they have just announced about 10 days ago in 721. Unauthorized access is prohibited in 723, and then access by state licensing authorities in 725, and the penalties in 727. So in detail, I'll go over each one, but I really highly recommend that you just download a copy of the regs, print them off, get a 3-ring binder, put them in there, and then study them up. So the current process for tracking violations, let me make sure, for tracking violations is commercial motor vehicle, learner's permits, and all those is kind of a current process. And this requires drivers to self-report positives in motor vehicles to conduct or respond to background checks and ongoing driver compliance. It's not, the system is broken. So again, why do we need a clearinghouse? Because the system is broken. We also, the Federal Motor Carrier Licensing and Database will keep the driver information secure. Only authorized users will be able to register the information. Other enforcement agencies, such as state driver's license, will only receive driver eligibility reports. Drivers can access their own information. So the clearinghouse will go into more detail, but again, it's a national database that will be mandated to be used beginning January 6, 2020 for all commercial driver's license. So it's to increase safety on the roadways, real-time access. So Congress really received a huge mandate, or mandated the DOT to implement this to protect the public. Give you a little timing in here. The final rule was published on December the 5th. So actually the regulations that we're talking about today have actually been in effect since January 5th, 2017. And they identified January 6th as the implementation date. So you see the hot link there? That's the link on slide 19, where you can download all of the regulations there. A little bit more on the timeline issues. So you've got January 5th, as I mentioned. You've got March 2019 with an informational launch of the website that came out. One of the things you can do right now is subscribe for emailed updates, and I'll give you the link to that at the very end of the presentation today. October 2019, the registration opens. January 6, 2019 is the implementation date for the mandatory reporting to begin, both electronic and manual queries. We'll talk about that. And then January 6, 2023 is the 3-year post-implementation. So for 3 years, you're going to have to do dual queries. So you're going to have to do the old paper queries of the past employers that hiring wasn't inside the database period of time, and then it'll gradually kind of bleed out over the 3-year period of time.
And I think, Tommy, the question that we all kind of want to know is, so who will be required to comply with the Clearinghouse regulations?
You know, Melissa, there is a big change for cities, counties, municipal entities. And I'm going to start with the bottom and I'll work back up. But in the past, refuse drivers for a city, trash truck drivers, whatever you want to call them, have not really, it's not involved in interstate commerce. So what they did is they changed the regulations and the wording of the regulation. I'm going to move one slide forward and come back to this one. If you look at the language, they amended the DOT regulations in what's called 382.103. They redefined who's covered. And so any traffic or transportation which affects any trade, traffic, and transportation described in Section 1 is covered. So really there is a huge leap forward of who the entire DOT, not just the Clearinghouse, but who the entire DOT regulations apply to. So it, again, when I give you that and I back up and I go, municipalities, counties, states who employ CDL drivers who operate a CM, commercial motor vehicle, on a public roadway. Huge, expansive coverage here. So anybody that's working in a public entity needs to understand that. So you got the state driver's license, the substance abuse professionals, the MROs, the third-party administrators, employers of those that hold CDLs, and the drivers themselves. So a huge expansion of coverage there.
Sure. Could you give us an overview of the queries to the Clearinghouse and who is required to do what?
I will. This is probably the heart of the Clearinghouse, is the query system. So you've got what's called a basic query. Think of a basic query is I've got to run a pre-employment query. And that means I've got to do what's called a full query of that driver. I've got to make sure that there's nothing in the database that shows that they've been in violation of drug and alcohol testing regulations. The way that you do those is you first do a limited query. And all the limited query is it's looking for information in the database concerning that particular driver. If there's none, it will come back none. You have finished your query at that point. If it comes back with a hit, then you have to do a full query, which means the FMCSA must verify specific driver consent prior to releasing. There's still some uncertain areas about exactly how these consents are going to be handled, but we think either the driver's going to register a cell phone number and going to consent, or an email address, or something else like that. So we're not exactly sure. We'll find out more probably next month. I'll actually be with the regulators again in about another 10 days, so we can get a lot more information from them. The annual query, so every 365 days, an employer is going to have to perform an annual query. And again, an annual query typically will be a spreadsheet uploaded to the database, and they will query all of their employees at the same time. If they get a hit, then they got to do a full query. Now, one of the things that the FMCSA just shared with on the query system, So you see down, I'm on the slide, consent request, and I'm down the red language that said, or duration of employment. So that was one of the things I got, the nuggets I got out of the Detroit meeting, was they're going to allow you to have a duration of employment consent for a limited query, or what we call an annual query as well. So you get one consent signed by the driver, you keep it in the file, and then you can do it continuously every 365 days. So every 365 days, you have got to run an annual query on your drivers. Doesn't have to be the same day. Doesn't have to be the same day for all the drivers. They basically are going to be looking at some point in the inspection route for what that's going to be. There's going to be a limited query form released, some kind of consent form released next month, or it could be later this month, that they announced in the Detroit meeting as well. So again, you've got pre-employment, full queries, and then you've got annual queries. I'm going to talk more about both of those. And if the driver says, hey, I'm not consenting, then they can't drive. So the driver must register with the Clearinghouse to provide consent. So one of the big questions we had moving towards these regulations is every driver in the country got to register? We found out they don't. If you've got a new hire situation, then the driver has to register. If you've got a limited query that turns up information, the driver's got to register. And at that point, then the consent must be in writing for annual queries, which we talked about. Employers must obtain a driver's consent before querying the violations. Again, we're not exactly sure how they're going to do that, but we'll find out some more somewhere next month. Drivers who decline have got to be removed from safety-sensitive functions. So here is where I recommend, you see my red language at the bottom, highly recommend that you start preparing an Excel spreadsheet with all the information in Excel categories across the bottom, by the first name of the driver, the last name of the driver, the date of the month, day, and year of birth, the driver's CDL number, the county of issue. Now, this is not anything that I saw in the regulations, but this is what I saw in one of the FMCSA slides. They actually had the county of issue in one of the slide categories. So I'm saying, okay, well, let me tell the employers about that. The state of issue. I suggest that you go ahead and get the driver's mobile number, because that may be the only way that you have of making a contact at some point. So it's not something you're going to upload into the database, but capture it now, because you're definitely going to probably have to use it down the road, Melissa. So again, this is just a real it's the heart of the whole system of how this is going to work. So what actions will users be required to take in the Clearinghouse? So you can see you've got 5 categories of users in the database. And each one of them have different requirements, and they've got, some of them can use assistants to do the work, to do the management. So you see, if there's an assistant, they have to authorize the assistant. If you're an employer, and say Wolf's your TPA, then you have got to authorize Wolf to be your TPA when you log into the system. So you can see the list across, and we're going to hit some of those a little bit more, but that's a good chart to kind of understand everybody has different compliance obligations. One of the things that we built into the new toolkit when we updated was the employer requirements. You see, the employer probably, out of the whole list, has probably got the most number of requirements. They've got to register. They can have assistance. They've got to select the TPA if they want to use one. They've got to request the driver consent, the query violations, and then report the alcohol violations. And then they've got to do the return to duty reporting as well.
Well, Tommy, can you please cover for us the issue of MRO and employer reporting responsibilities?
glad to. I've got some, if you'll see, my first landmine is showing up on this particular issue. So an MRO has a certain period of time, and really they've entrusted, the DOT has pretty much entrusted the MRO to be the gatekeeper. They very much trust the MROs, highly regulated group, and they got to report within 2 business days all verified positives, adulterated substituted drug test, or refusals to test that require determination. So what refusal to test would the MRO have to have an opinion on? Shy bladder. That's typically the only refusal that the MRO weighs in on. There may be a couple of other definitions that they may, but typically that's the only one. What if they get, this is a great question I got the other day. What about split specimens? What if the driver asks for a split specimen to be tested? Do you hold off on making the report? No. You make the report, but if the split comes back and will not confirm, is non-confirmed, then the MRO has 1 day to go into the database and make a change in the result. So 2 days to report, 1 day to change. Here's the landmine here. What about the MRO's timely review of laboratory and other things and reporting and uploading of information? You've got to make sure that your MROs are timely reporting everything. And typically, Wolf is your third-party administrator, can easily audit that function for you because you as the employer are responsible for the actions of the service agents you use. So again, highly important that you have somebody looking over the shoulder of the MRO to make sure they're timely reporting. One of the wise counsels I'm giving is maybe give a little time before you pull the trigger on discharge. You may have a verified positive, but there's a lot of reasons why a driver may contest things from time to time. And if you can just do an unpaid suspension before you move to discharge, you may not have to unwrap the string on that one. So just consider a 10-day unpaid suspension pending discharge is a better move than a discharge. The MRO and the CP, one of the things is retention of records and holding records. So no person may obtain the individual controlled substance records held by an MRO or the consortium without the release of the individual driver. Now, there's nothing that prohibits the sharing of information with what are called service agents under the DOT. So we're talking about kind of outside entities and outside parties as well. So the employer's reporting responsibilities for alcohol. So what if, for instance, you get a driver who gets a positive alcohol? Now, also the definition of alcohol, positives have changed to alcohol test results with an alcohol concentration of 0.04 or greater. That's the new definition of a positive alcohol. So don't use the positive. For a refusal, you've got 12 different types of refusals under the regulations. So if somebody calls a refusal, make sure it's also a refusal under that particular regulation. And then the employers have to report that drivers have successfully completed all the SAP, Substance Abuse Program, follow-up reports. So the potential landmine here is inaccurate clearinghouse report is made by an employer. You got to train the employee. You got to train your supervisors on what a refusal is under DOT regulations. You've got to train them on it's got to be reported at third business day, and that it's the 0.04. So what about a 0.03? Is that reportable to the database? No, it's not, because it's not 0.04, so it's not a reportable up. So the avoidance is train your supervisors. What we decided to do is we actually created a brand new form for employers in our toolkit. We now have 23 forms in the toolkit. Created a brand new form to make sure the employers knew exactly what they had to report, the time period to report it, and then also we put a driver response at the bottom of it. I have found it better over the years as a management labor attorney to find out what your employees' intentions are or find out whether they just kind of agree with what you found. So we put a driver response section, much like you do on the bottom of a final written warning, and give the employee a chance to opine on that issue. So again, the employer's responsibilities are if the driver receives a positive alcohol, you report it up, adulterated, substituted, things like that. The MRO is typically going to report those. So you've got the refusal, and we talked about the actual knowledge. We're going to talk a little bit more about actual knowledge later as well, because I do think that has some issues. And then retention of records. So even though it's kind of buried in the regulations, 382.401, the records of all driver violations have got to be retained for a minimum of 5 years. So that's a long time. It probably exceeds a lot of your retention policies. So this is something that Wolf can help you with and make sure that you have fulfilled this requirement. So any record of a driver violation needs to be retained for 5 years, and that includes a clearinghouse record violation. Access to facilities. So I mentioned before that cloud providers were kind of covered by the regulations, so here they are. So if you're a service agent, which means anyone that has or houses data that's part of a driving record, is considered a service agent. So again, even a cloud provider. But you've got the Secretary of Commerce, you've got the Secretary of Transportation, you've got DOT agencies, all are you're mandated to give access to these records. And then you got National Safety, Transportation Safety Board that also has clear rights, especially if there's been a crash of some nature. So a couple of new definitions. Yeah, go ahead, Melissa.
I just wanted to find out, so how are our drivers to be identified in the clearinghouse, and do the drivers have their own reporting obligation?
Great question. So on the driver identification, so in the past, many of you have identified your drivers by their Social Security number. Don't do that anymore. That is really a huge change in the regulations. You're going to identify them by their commercial driver's license number and state of issue. So driver's license number, and then, AL or G, whatever state you're in, is going to be at the end of that. So don't identify them any longer by Social Security Administration numbers. And then the negative return to duty, that's a new definitional change as well. An alcohol test with an alcohol concentration of less than 0.02. So like a return to duty test. So no longer is it a negative alcohol test. It is an alcohol test with an alcohol concentration of less than 0.02. So these definitions need to be in your policy update, which is what we include for policies as well. And the driver identification, again, this is just the subsection, the 382.123 clearly says don't use Social Security numbers any longer, and use only the driver's CDL number and state of issue to do that. But again, remember what I told you, when you're harvesting information from the drivers, get the county of issue. Now I had a question the other day. You may have to ask them to also show you if they have a regular driver's license in addition to their commercial motor vehicle license, because their regular driver's license I know will have the county of issue. So if you need to harvest that from them, that's a good idea as well.
Well, can you tell us about the sticky issue of reporting of actual knowledge of the DUI to the clearinghouse?
Yes. Let me hit one. Notice I'm going to hit one other issue before I do that. One of the issues is the driver has their own obligation to make a report. So say a driver is working maybe they work for a county school system. Maybe they're a bus driver during the week for a county school system. And on the weekends, they're hauling cement for ABC Cement. So you've got, they're basically, and neither one of the employers probably know about each other. So under these regulations, if the driver gets a positive working for one commercial motor vehicle carrier, then they're mandated to report to the other carrier by the end of the business day following the date they got notice. So say they have an alcohol violation at 0.04 or higher, they've got to give notice to that other employer, hey, I had an alcohol violation at work you need to know about. And they probably have to give them some paperwork to be able to do that. Brand new requirements, never been part of the regulations in the past. I recommend one of the things we just incorporated is in the pre-employment form, I actually put a question in there, is are you currently employed by any other entity where you're using your CDL? And I want to just have them either yes or no, and if yes, you list. Because I think there needs to be a communication between the two employers. Oh, by the way, Joe's over here, the HR person calls under here. Hey, we just hired Joe. He showed us that he was working for you at the same time. Just to have a dialogue if something comes up in the future. It's just a brand new requirement, and I think that you're better to know if they're working for another entity. So let's talk about the sticky issue of actual knowledge. So when I started working in this industry, I thought actual knowledge was like maybe the DUI they got the night before. It's not. So if you get an off-duty DUI that's not in the commercial motor vehicle, there's not that's not considered actual knowledge of substance abuse. So there's a clear definition that you have to actually be operating, get a driving citation while operating a commercial motor vehicle and under the influence of drugs or alcohol. That's actual knowledge. But anything else is a little bit of view of interpretation. Examples. Maybe you find beer cans in the floor of the driver's truck when they come in. I think there's a good interpretation that's actual knowledge, but the way I would do it is take pictures of the evidence. Preserve the evidence. If you find a marijuana cigarette in the ashtray, take a picture, preserve the evidence. And that is going to be so important. And then train your supervisors on the definition of 382.107 actual knowledge. Very specific. So what we did is we got an actual knowledge form in the forms pack, and then we attached as page 2 the regulations. So anybody that's going to make an actual knowledge observation would have the regulations to look at right then. So actual knowledge is not the DUI the night before. It's actually you saw somebody smoking, drinking alcohol, staggering. You had actual knowledge. So that's a new one. One of the things that I saw, Melissa, when I was at with the FMCSA up in Detroit, is they flashed up on one of the screens a pull-down page. So we don't know if this is what it's finally going to look like, but you can see this would be the data reporting by the employer. The violation, is it drug or alcohol? The types of refusal. It had actually 7 different categories. It had an actual knowledge violation pull-down menu with all kinds of places you could upload information or upload evidence into. When did it occur? The state of the violation, the detailed description of the violation, and documents and evidence uploaded for violation. So it kind of gives us a preview of the things that we need to make sure that the employers are collecting when these issues come. So that was a very helpful thing for me to see when I was with them. So Clearinghouse registration, recording data, what the employer wants to know to identify you as the employer, the company name. One of the brand new things, categories that we put in throughout the policy and forms is the U.S. DOT number for the employer. Previously, we had not used that information, and really, I had never seen it included in the drug testing policy, because everywhere I'm seeing documents from the FMCSA, they're mandating the employer input your DOT, your U.S. DOT number. So again, highly important that you start using that. And like I said, we actually put it in the intake documents for policy support now.
Well, Tommy, can you tell us the entire issue of reporting to the Clearinghouse and then the ramifications in Common Sense Council?
Thank you, Melissa. I think now, as Melissa is working for a TPA, so one of the things we're going to talk about right now is what are the reporting responsibilities of the TPA. Some of it depends on how much authority that you as the employer have granted to the TPA. if you granted them full authority, then they have the right to fulfill all your reporting responsibilities to the clearinghouse. One of the things that I've told Wolf is that they need, if they're going to make a report of either refusal or actual knowledge, that they make sure that their employer clients have given them evidence. I'm going to give you a quick evidence course. So in law school, you take a full semester of evidence, and many times there are advanced evidence courses in law school. So evidence is contrasted with hearsay. So hearsay is something that's not admissible in a legal proceeding because it's not considered reliable enough to be accepted by the fact finder. So when I think of evidence, I think of things like affidavits. I think of a declaration signed under penalty of perjury in accordance with the definition used by the United States Code. I think of photographs that are authenticated. Think of other things that are somehow authenticated, maybe things that are kept in the ordinary course of business or as public records and things like that. There's a whole category of what's evidence, and what is not evidence is hearsay and not acceptable. The reason that is so important in this new system is because if you are going to make a report to Wolf and say, hey, I got somebody that walked away and they're refusing to be drug tested, they're going to be asking you, well, what evidence do you have, or what can you submit to us that will satisfy the evidentiary issue? So within the forms pack that we built, we have declarations that at the bottom of several of the forms, the refusal, the actual knowledge forms, and in the final report form, we have a declaration under penalty of perjury that would pass for the United States Code definition of how to do that. So the employee remains responsible, even though it may assign the responsibility to the third-party administrator. So here's the potential landmine is, what if the TPA doesn't make the report? So within the documents, you need to have typical indemnification languages, or who's responsible for what. A lot of that is just making sure you know who's responsible. So making sure that those are defined in the contractual agreements is important. So you've got the SAP reporting response. Really, the SAP only has kind of one area they've got to report as a substance abuse professional, and that's if somebody hits a positive, they've got to be interviewed, they've got to have a face-to-face meeting with the driver, they've got to they've got to define what the educational requirements are, what the follow-up drug testing requirements are, typically a minimum of 6 tests over 12 months. And if you don't have a particular SAP in your area, there's some wonderful nationwide SAP referral networks that you can list as well. So again, if you're going to give somebody a last chance agreement, make sure you got a written document. So within our forms pack, we actually have a work continuation agreement and a last chance agreement, depending on whether they come to you as a cry for help or whether they come to you as a violation. And in these days and times, it is so hard to find drivers that we're going to see more and more employers grant last chances to employees. Melissa, I will tell you that one of the screen issue, and part of the reason you got all the red on this particular screen is because the reporting to Clearinghouse has got to be truthful and accurate. So again, if anyone makes a false, but read the way this word's out of the regulations. FMCSA prohibits anyone from reporting false or information that should be known as false or inaccurate. So that is a watery definition. So you have got to make sure that whatever you report is based on evidence and not based on hearsay. So if you make an inadvertent error, what I consider this to be a safe harbor under the regulations, you need to go back and make that edit and change that. So anyone violating those is subject to both criminal and civil penalties. So the potential landmine, if they make a report with little or no evidence, the DOT fine, the lowest DOT fine you'll find is $1,100 a day fine, and it can go up to $11,000 per violation. Or my concern is that you may have say the DOT finds that you made a report that was inaccurate or false or should have been known to be inaccurate. The employee you've already fired, the employee then uses that information in some kind of state court proceeding to say under some kind of wrongful discharge theory. So I'm just saying, be careful if you're going to take action that you have evidence that would stand up in some kind of administrative proceeding. So again, signed declarations, affidavits, best to present, and then best to present your driver with everything you're going to present to the clearinghouse. In fact, the clearinghouse actually mandates that you serve the driver with a copy of what you're going to report to the clearinghouse. So I think go ahead and find out. Ask on the form, on Form 23 in our pack, we have a driver response section, and if you give it to them and you prove that you gave it to them and they don't respond, I consider that under law what's called a tacit admission. So document the meeting, the oral statement of the driver, and the certificate of service. Again, these are brand new regulations, and they haven't been interpreted by anyone yet. So, again, you don't want to be the test case to deal with these. There is a chart within the regulations that allows you to that kind of gives you a good understanding of what those look like. So the notice to the drivers and the employers. So FMCSA is mandated to notify the drivers when new information is added, when it's revised or removed. So again, I think they're going to harvest emails and text messages, but they're mandated to send by United States mail if they haven't gotten some other way to communicate with the driver. The driver has, under 709, has the right to access the information about themselves at any time with absolutely no fee or clearinghouse database fee. Well, so let's take a minute. We'll talk about clearinghouse registration. When you register, when an employer registers in the clearinghouse, they're going to have the ability to assign a third-party administrator to perform their functions within the clearinghouse. So you've got to find out, you've got to consent to that, and then you've got to agree to that. So the potential landmine is failing to register. So if you're an employer and you fail to register, you're in violation of the regulation. So again, registration will open next month. You really only need the bits of information, US DOT number, and the other information I showed you. And then your service agents have got to register. So one of the things we thought about is how do you make sure that you as the employer know that the service agents you're using are registered. So within the forms pack, we built a certification to do that, to just make sure. But they need to start registering in October. So that'll be a huge. Now again, you don't have to register your employees, or the drivers don't have to register. It's not mandated. But I think you ought to obtain some kind of consent from them, or some kind of acknowledgement from them that they registered in there. So what if you register, and how long is it good for? So you can see on 713, the registration is valid for 5 years, unless canceled or revoked by the FMCSA. It will cancel registration. It is inactive for 2 years. So if you just register and do nothing, you can re-register after that, but it's automatically shown inactive. Right to revoke it if there's any. Say maybe you're a serial false reporter. They may revoke your permission to access the database at that point. So again, they can revoke it, and I'm sure that they'll give fair notice and ways to do that. Let's talk a little bit about procedures for correcting information. I would say if I could have put a bigger landmine picture on this slide, I would have. This is probably the biggest landmine in the entire regulations. It is providing a dispute resolution procedure called a driver petition in 717. So if the driver disagrees with what you report up to the database, the driver can file a petition via the FMCSA database system detailing the reason they believe the information is inaccurate and that there's and the evidence they use to support their challenge. I think that this is going to be at no charge to the driver, and this is your biggest landmine. So what if they file a petition and it's found that you didn't produce evidence, that what you filed with the clearinghouse is considered hearsay or inaccurate or whatever, then you can both be penalized under the regulations for a record-keeping violation at $1,100 a day or $11,000 max fine for that. So I will tell you that not having legal evidence and only uploading hearsay into the database is extremely risky. Now, I think that the FMCSA is going to police this, but this goes back to that whole idea of showing the driver and asking the driver to respond before you make the report up to the database. That way, you can deal with the issues with the driver initially, and, maybe I think that's the best way to do that. So the availability of information about the driver's drugger will not be available to an employer conducting a query after the return of duty. So the driver goes through the SAP process. He's get counseling. He started on the follow-up testing process. Once they go and get their return to duty tests, and that's been successful, comes back as a negative, and that's reported up to the database, the driver's information is removed from viewing by anybody in the database. I'm sure it doesn't disappear, but it's very much at that point removed. So there's two reports the employer is going to make. It's going to make one report at the point that the return to duty test comes back as a negative. If it comes back as a positive, the MRO is going to make the report. So don't worry about that. But if it comes back as a negative, it's the employer report on the return to duty test. So again, now fees. Now this just came out, so we did not know this until just recently. But on the fees, there is I'm sorry, there's supposed to be a slide in here. The fees are $1.25 per query a year. So there's an annual fee per driver of $1.25. So the way the FMCSA has explained that is that you have to pay this, the employer has to pay this, and you basically say how many drivers you got. They've got a query bundle, and they've got the plan cost. So if you've got 100 drivers, your query cost is $125 for the year annually. Now, if you hit if one of the queries, the annual query, comes back and hits something, you're going to then do a full query, but there's not going to be any additional cost. Now, they may have a certain period of time you got to do the query in and things like that, but they said so far there's no additional cost for a full query after you get a hit on an annual query. So again, that's on the FMCSA website, and that was something just defined about 2 weeks ago for us. So unauthorized access, reporting inaccuracies and things like that, again, specifically prohibited. If I've got employees that are going to have access to the Clearinghouse database, I'm going to get them to sign some type of strict confidentiality provision. I'm going to train them on, I'm going to have a job description and confidentiality pledge by them, because you can get in real trouble if you use this information for any other purpose than just to find out if a driver is eligible to drive or not. So again, you've got to make sure that whoever you grant access is an employer or TPA, that you've got some tight controls over them and some pledges of confidentiality. Access by the state licensing authorities in 725. So every one of the commercial, what are called the state chief commercial driver's license official, has access to the base. So if somebody gets an arrest a DUI after hours, more than likely that commercial driver's license will be suspended. And it's not a report that you as the employer have got to make. It's more than likely that will be taken care of by the state licensing authority, which would have happened in the motorcycle case that I talked about at the front. So I think that'll be taken care of. So the penalties I said I would mention in 727. So these are basically the record-keeping fine penalties. You've got $1,100 a day. I've mentioned that a few times. You've got a max penalty of $11,000. You've also got a knowingly falsification of records at $11,000. And then you've got a driver penalty of $3,750. So again, those are all significant issues, and there are some criminal policies in there as well. I hadn't heard much about what those would be. So the last thing I want to kind of leave you with is the employer obligation to promulgate a policy. So this is in 382.601. So there's new sections added in. It's now section 12. So under that 601 section, you've got all of these new requirements that see the way it's worded, the requirement that following personnel information collected and maintained shall be reported to Clearinghouse. So you got to give clear notice to your employees of all these areas that are going to be made reports. So the potential landmine here is not educating your employees, not adopting a new policy. And again, those are fairly stiff penalties. This would be a record-keeping violation. If they really want to be extremely strict, they could do it on a per-driver basis as well. So highly recommend that you update policies as soon as possible. So we've been working with Wolf clients already. I have told Wolf I'd be more than happy to facilitate policy development either through our law firm or work directly with Wolf to develop those. Sometimes it's hard to go to your boss and say, I need to hire a new lawyer. So I have told Wolf that we will be more than happy to, if you will fill out a policy intake. I have learned that until I get a policy intake, I really can't do this or do an estimate for you. Typically, we do this on a flat rate basis. So once you fill out the policy sheet, we know exactly what work it's going to take, and we think that'll go fairly quickly. So getting your ducks in a row. So update your FMCSA policy and forms toolkit. You want to adopt your internal clearinghouse reporting protocols, job descriptions, and confidentiality pledge that I mentioned. You want to modify your service agents agreements, train covered employees and supervisors. And then for MROs, SAPs, and PPAs, you've got to adopt your internal protocols, notify the clients, consider contractual modifications as well. And then probably pricing structure in this industry is going to go up a little bit because there are a number of requirements. So the FMCSA has got information that they're putting out as well. So register the company, designate the third-party administrator, set up the assistants, and encourage drivers to register. So they highly recommend that you subscribe to their Clearinghouse email database, and I totally recommend that you do as well. There's some Clearinghouse fact sheets there. You can contact the Clearinghouse and post questions if you want to, but you can see the Clearinghouse registration right there. So, Melissa, we are finished and fully ready to answer just a few questions. I don't want to take us over much at all, and if you got a few that you've seen, I'll be more than happy to try to answer those. Yeah,
thank you, Tommy, for that valuable information. We do have a few questions. I know we're really close on time, so we'll review a couple of those, and then everyone just be confident that we will get an email sent out. Tommy will actually give his attention to these questions, and the ones we don't have time for, we will definitely get a response out to the group. So one of the questions that were asked is, can an employer perform batch queries for multiple employees?
So right now, the FMCSA is not providing us some information about batch queries. They will tell us next month about how they will handle batch queries. They want to make sure that the database cannot be compromised. But what I will tell you is start making up your Excel spreadsheets, because at the point they give the okay, we think the Excel spreadsheet format for a batch query will be what you want to have ready to go. Melissa?
Perfect. And will public school bus drivers need to be checked?
Yes. So anybody that has a commercial motor vehicle that's in the traffic or roadways, again, highly expansive coverage of this new regulation.
All right, we're going to do one more here before our time. I know it's on the dot. So I am confused on the breath alcohol. When was this changed to 0.04 from the 0.02?
All right, so 0.02 is considered a negative alcohol test, or below. I'm sorry, 0.02 or below is considered a negative alcohol test. A positive alcohol test is now considered a 0.04 or greater. 0.03, you're going to send the driver home for 24 hours and then retest them to see if they're negative before you're allowed to return them to work. Now, in your policy, as a matter of HR issues, you can also take disciplinary action against drivers at 0.03. You could actually take it at 0.02. I don't recommend that. I think that's risky. But you can actually define in your policy from an HR standpoint what you're going to do with the employment status of the driver. Okay. Melissa?
Well, that's about all the time we have for today. Again, Tommy, thank you so much for this valuable information. It has been absolutely wonderful. We will be sending information out with the webinar. I know Tommy meant there was a lot of links in there that people will need and information, so we'll be getting that out to you guys, as well as the unanswered questions. We anticipated we would have a lot of questions, and we do, so we will definitely be responding to those. We should have something out, I would say, to you guys at the beginning of next week. We'll get that. In the meantime, Tommy's information is here on the screen. If you have any questions or you want to speak to him regarding policy review, or you can reach out to us at Wolf. Again, we do thank you for your time. Please be on the lookout for our demo for our Wolf 1. That will be assisting with the compliance needs with FMCSA, so we're really excited about that. And if you would like to hear more about it prior, please reach out to us directly. But again, thank you everyone for your time. It's been an honor to be able to listen to this with Tommy, and we appreciate your time. Thanks so much.